Welcome to the InfoSec Insider podcast, brought to you by URM, the UK's leading information and cybersecurity specialists.
Hi, my name's Annie and I'm joined here today by Martin Brazier, who's one of our senior data protection consultants here at URM. Welcome to another episode of Talk DP. So today Martin and I are going to be discussing the data protection issues around workplace monitoring. So since COVID, there's been an increasingly mobile workforce with hybrid and home working becoming the norm. And because of this, quite a lot of organisations are thinking about how they can sort of keep an eye on their employees. So to kick us off, Martin, can you just talk us through whether anything's changed in recent years regarding data protection in this area?
Well, the ICO issued some guidance on employee monitoring in October of last year. And that was prompted, of course, by an increasing number of people working from home, at least for part of their working week. And the increasing gig economy means that lots of employees work irregular hours, which need to be monitored. There's also been some work done by various groups to see how workers feel about that monitoring. So to start with, the Office of National Statistics reported that over the period of September 22 to January 23, 44% of workers declared that they were in hybrid or home working. And a Forbes survey suggested that 63% of workers worked from home at least some of the time. So things are changing for a more home working environment. And a larger number of staff are using mobile devices, some their own as part of bring your own device policies. And in some areas, in some industries, employee monitoring is mandatory. In financial trading organisations, for example, employees have to be monitored to make sure that there's nothing peculiar going on.
So is there sort of a single definition of workplace monitoring?
No, the ICO defined monitoring employees as any form of monitoring of people who carry out work on an organisation's behalf. So this would include not only direct employees, but anybody who performs work for that organisation, regardless of the nature of the contract. And I think it's worth saying here that, you know, for some time, workers have expected some level of monitoring as part of employment. It kind of goes with the territory. They understand that their employer wants to be sure that they're at work, they're being productive, they're working their contracted hours, they're not abusing their employer's assets, and they're not committing theft or fraud or whatever. But as the potential for monitoring becomes more sophisticated, some concerns have been expressed, and the BBC reported, for example, that an increased employee monitoring is fueling employee distrust, and that some organisations have kind of stepped over that line of what the workers expect. Also, Parliament reported on the impact of home and hybrid working, including those impacts on workers. And the Trade Union Congress, the CUC, has now issued guidance for monitoring and offers help for workers who feel that they've been unfairly monitored.
And have there been any advances in technology that are relevant here?
Indeed, there have, yeah. There's, like in many areas, there are far more sophisticated ways by which employees can see what their employees are doing or indeed not doing. Monitoring can include monitoring phone calls, emails, messages. There's video and audio surveillance, monitoring activity on devices, and the tracking of vehicles, for example, including dash cams. But it's also starting to go further, and mobile phone apps can be used for workers who log on and off sites, whereby they can only do so if the GPS on their phones says that they are where they should be. And there's some really sophisticated services being offered, including psychosocial risk detection and management, where various psychological and physiological reactions are measured, which are said to be indicative of changes in the perception of the employee being measured. So they claim that this can help reduce fraud, data loss, bribery, and also can alert an employer to employees who are maybe struggling with well-being or mental health. So yes, it's getting very sophisticated.
How do we establish whether monitoring complies with data protection legislation?
Well, as always, of course, the UK General Data Protection Regulation, the UK GDPR, and the Data Protection Act 2018 set out the requirements for processing personal data. And of course, when you're monitoring employees, that's exactly what you're doing. The first data protection principle requires that processing must be fair and lawful. So the first step is to determine the lawful basis under Article 6 of the UK GDPR. It's really important to get this lawful basis right first time, as there are a lot of difficulties if you decide that you have to change it later. Often the only potential basis would be legitimate interests, and in that case an employer should carry out a legitimate interest test to balance their interests with the employee's interests and rights and freedoms. If an employer decides to use consent, for example, this brings in an administrative burden of obtaining and recording that consent, and what they might do if the employee decides not to give consent, because that employee-employer relationship is an imbalanced one in favour of the employer, and employees shouldn't really be put in a situation where they have no real option but to consent. The one word which crops up in the Article 6 lawful basis is necessary. So you need to ensure that the data you collect and process is necessary for the purpose you've identified. If it isn't, it's unlikely to be lawful. And monitoring workers, particularly in the more sophisticated means, often includes processing special category data. And in that case, an employer would need to identify an additional lawful basis under Article 9. All biometrics, fingerprints, iris scanning, facial recognition, voice recognition, they're all special category data, and they require enhanced levels of justification and protection if you decide to go ahead. And an employer should also ensure that monitoring is lawful in a general sense, not just for data protection law, making sure that it complies with all other legislation.
And then on the flip side of that, how do we show that the processing's fair?
The general guideline is to establish fairness is whether the employees would reasonably expect it, and not in any way that would cause unjustified adverse effects on them. It has to be proportionate. This can be very context specific because some workplaces, industries and professions have different expectations than others, as we mentioned earlier. In some circumstances, you've got to carry out a data protection impact assessment, or DPIA, before carrying out monitoring, and the ICO guidance suggests that. Even if a DPIA isn't mandatory under the legislation, it's highly recommended that you do one anyway. A DPIA will help you consider whether the planned use of the monitoring is fair and lawful, and it also provides a methodical approach to assessing any risks. It also helps record your thought process and decisions to help you demonstrate compliance later. A key question to ask is whether there is any less intrusive means of achieving the purpose, and if there are any lines of communication that should be exempt from monitoring, such as communications to trade union representatives or calls to workplace health and wellbeing services, for example. And it's always useful to engage with the workforce to gauge their views before proceeding, because once you've started, it's often too late to roll it back.
We have to be transparent about what we're doing.
Absolutely. Transparency is about being clear with people about how and why you're processing their information. And of course, it's fundamentally linked to fairness. And fairness and trust start with transparency, and performing monitoring covertly, more of which I'm sure we'll get to later, or without prior notification, is clearly unfair and could negatively impact trust. Workers have the right to be informed about the collection and use of their information, and the information must be provided in a way that's readily available, accessible, and easy to understand. And this is a good point to mention the need to identify the purpose for monitoring and the purpose limitation principle in the legislation. If, for example, an employer has given workers an access card to enter their premises for the purposes of security and crime prevention, and it's included that in the information provided to them, that would be fair. However, the purpose limitation principle prevents you from then using that information for another purpose, such as determining if somebody was late for work, for example. To use the information for monitoring timekeeping, you've got to say so up front.
Can workers object to monitoring by their employees?
In short, yes, they can. It is a right under the legislation. Employees can object to an employer collecting and processing their personal information for monitoring, but only in certain circumstances. Specifically, a worker can object where the lawful basis is public task. So that's a performance of a task carried out in the public interest or as part of an official authority that's vested in the employer, or legitimate interests. If they do object, it must identify specific reasons why they're objecting to the monitoring, and they should be based on their particular situation. However, the right to object isn't an absolute right, and the objection can be refused if it can be demonstrated that compelling legitimate interest for processing overrides the interests, rights and freedoms of the worker. And there are other rights, of course, as well, and that would include the right to make a subject access request, or SAR, where the employer must provide the information they hold about them, including from any monitoring, unless an exemption applies. It may be challenging to respond to a SAR if the monitoring system that you're using collects large amounts of information or is mixed in with the personal information of other people. This is especially the case if the systems used don't store information in a way that makes personal information readily retrievable.
So are there any monitoring tools available that automate decisions about employees, and how would that work with compliance with the GDPR?
Well, the answer is yes, there are, and increasingly so, where tools for monitoring workers become more sophisticated, and automated processes, sometimes known in the industry as people analytics, are used for security purposes, managing performance, monitoring sickness and attendance, and so on. And those systems are used to improve organisational efficiency and also compliance with employers' policies. These tools can process huge amounts of data in real time, which is then used to make predictions, inferences, and decisions about employees on both an individual and a collective workforce level. The UK GDPR has provisions on solely automated decision making that have any illegal or similarly significant effects, including any profiling. The legislation defines solely automated decision making as a decision made by automated means without any meaningful human involvement. It can also involve profiling, where employers use information from a number of sources to make inferences about future behaviour or make decisions about employees. The UK GDPR Article 22 restricts employers from carrying out solely automated decision making that has any legal or similarly significant effects on employees, such as something that affects legal rights, such as the right to work. Similarly, significant effects are more difficult to define, but they're likely to include decisions that significantly affect somebody's financial circumstances, such as changes to a worker's pay or affect a worker's employment, such as dismissal. It's also unfair to disadvantage workers who ask for a human intervention in decision making. And of course, employers must be transparent about automated decision making in the way that they are transparent about everything else, and it should be included in their information to employees up front.
I think you began to touch on this earlier, but just to sort of bring it in as its own question, can employers carry out covert monitoring of their employees?
Well, covert monitoring means carrying out monitoring in a way that's designed to ensure workers are unaware that it is taking place. and it's unlikely that covert monitoring can be justified in most circumstances. There may be exceptional circumstances, such as preventing or detecting suspected criminal activity or gross misconduct, where you may want to use it. For transparency, again, we're talking about transparency, employers should outline in their policies the types of behaviours that are not acceptable and the circumstances in which covert monitoring might occur. Covert monitoring should only be authorised by senior management. It's essential to carry out a DPIA. There needs to be sufficient grounds for suspecting criminal activity or gross misconduct, and that informing workers about the monitoring would prejudice its prevention or detection. Covert monitoring shouldn't be used in a routine way. It should be targeted to obtain specific evidence within a set time frame, limited to the shortest time possible. Covert audio or video monitoring shouldn't be carried out in areas where workers would reasonably expect to be private, such as in the toilets or changing rooms, or to capture communications that workers would reasonably expect to be private, such as personal emails or phone calls.
So, final question for you, Martin. Do you think there's an ethical aspect to be considered with employee monitoring, and should employers try and balance that with the compliance?
If an employer's considering any implementation of workplace monitoring, it's essential that it's compliant. I would suggest obtaining specialist advice to help with data protection compliance and conducting a DPIA, because workplace monitoring may involve areas of compliance and technologies with which employers are not familiar, particularly if it's the new technologies. As with all personal data processing, monitoring employees must be both necessary and proportionate, which I think takes us partway to answering whether it's ethical. Monitoring employees can jeopardise the sort of delicate balance of trust between employer and employee. And there are some types of routine monitoring with which employees are perfectly happy because they understand the purpose and they don't feel that they're intrusive. But when monitoring isn't transparent, or when it's complex and opaque and new technology is implemented, the risk is always that that precious trust is eroded. There is a view among some data protection commentators that if something is lawful, then it's ethical. I agree that it's not for data protection advisors to say if or how an employer should monitor their employees or not, only whether it complies with data protection law. But as a final thought, perhaps a more prudent approach with employee monitoring should be the thought that just because we can do something, it doesn't necessarily mean that we should.
Well, thank you so much for taking the time out to talk to me today, Martin. And for those listeners that want to learn a bit more about this topic, Martin's written a really great blog that can be found on our website, urmconsulting.com, and that is called The Data Protection Considerations for Monitoring Employees. So thank you very much, Martin, and thanks for listening. See you next time. If you've enjoyed this podcast, we would really appreciate it if you could spare a moment to leave a rating or review at ratethispodcast.com/InfoSec Insider. To listen to more episodes, you can find us on Spotify, Apple Podcasts, YouTube, and Podbean.
Thank you for listening to URM's InfoSec Insider podcast. For more information, visit our website at urmconsulting.com.